Judicial power. The judicial power shall be vested in one Supreme Court and in such lower court as may be established by law. Judicial power includes the duty of the Court of Justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or access of jurisdiction on the part of any branch or instrumentally of the government.
Article 8, Section 1. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Supreme Court, Court of Appeal, Sandigan Bayan, and Court of Tax Appeals. Ang kapangyarihang panghukuman daw ay dapat ipagkatiwala sa isang Korte Suprema at sa mga ganitong mababang hukuman ayon sa maaaring itatag na batas. Yung hukumang mga nabanggit ay Supreme Court, which is the task is to interpret the meaning of law, to decide whether a law is relevant to a particular set of facts, or to rule on how a law should be applied. Next is Court of Appeals. Its function is to vested with the power to review all final judgments, decisions, resolutions, order, or awards regional trial courts and quasi-judicial agencies, instrumentalities, board or commissions, except those falling within the appellate jurisdiction of the Supreme Court. Third is the Sandigan Bayan. It tries and decides criminal and civil cases against government officials and employees accused of graft and corruption and similar other offenses. Last is the Court of Tax Appeals. It addresses the adjudication of appeals involving internal revenue tax and custom cases of the Commissioner of Internal Revenue and the Commissioner of Customs, respectively. Regional trial courts shall exercise appellate jurisdiction over all cases decided by metropolitan trial courts, municipal trial courts, and municipal circuit trial courts in their respective territorial jurisdiction. Metropolitan Circuit conduct preliminary investigation of crimes alleged to have been committed within their respective territorial jurisdiction which are cognizable. Municipal Circuit Trial Courts. Every municipality in the Philippines has its own municipal trial court. It is referred if it covers only one municipality. Otherwise, it is called Municipal Circuit Trial Court if it covers two or more municipalities.
And now we will tackle about the quasi-judicial bodies. So the quasi-judicial bodies is the administrative agencies which can interpret law. Such actions are able to remedy a situation or impose legal penalties. So dito po is meron po tayong arbitration panel or yung tribunal board. And dito po is ginagawa po siya for alternative dispute resolution in a way na mareresolve po yung dispute outside the judiciary courts. And limited lang po yung powers nila to specific areas such as the financial markets, employment laws, and the breach of contract of disciplines, conduct rules, and such. Una na nga po dito yung Civil Service Commission, in which it adopts rules for examinations, appointments, promotions, transfers, and such or the like. So, ito po, sila po yung nag-a-administer ng tests to determine the ability of persons to perform the required duties, or sila po yung nag-a-administer ng test para malaman kung eligible po yung isang tao, nagampanan po yung isang particular duty sa civil service. And then, the COMELEC or the Commission on Election is to enforce and administer all laws and regulations relative to the conduct of elections, plebiscites, initiatives, referendums, and recalls. So, as we all know, yung Commission on Election, sila yung namamahala when it comes to elections. And then the Commission on Audit or the COA ito sila po yung nag-examine, nag-edit and nag-audit, and nagse-settle ng lahat ng accounts pertaining to the revenue and receipts, and also the expenditures po and the uses of funds or kung saan ginamit yung funds as well as the properties. And para din po ma-assess or ma-address kung tama po ba yung budget doon or exage po yung naging expenses. So, yun po. The Civil Service Commission, the COMELEC, and the COA. And yung iba pa pong quasi-judicial bodies ay i-continue ni Ms. Ramones.
The Office of the Ombudsman, as we know it today, was created with the 1987 Constitution, which placed a higher level of accountability for government workers based on the principle that public office is a public trust. What does the Office of Ombudsman do? An ombudsman has the power to investigate and file compliance against otherwise influential organization or high-ranking officials. They often have the power to request key documents, interview individuals, and order a legal investigation if necessary, if agreed to ombudsman's rulings are legally binding. Role of ombudsman. The dictionary generally defines that ombudsman as a government official who investigate compliance against the government or its functionaries. In the basis of these functions, the ombudsman has also been described as a public defender, a grievance man, a watchman, over the laws watchman, voice of the citizen, and citizen counselor. Essentially, the ombudsman protects citizens against injustice committed by the civil officials. What is the National Security Commission? The National Security Council is the President's principal forum for national security and foreign policy decision-making with his or her senior national security advisors and cabinet officials, and the President's principal arm of the coordinating these policies across federal agencies. What is the main purpose of national security? The primary objective of national security policy is to fulfill the national vision and safeguard the national interests, which include, among others, the protection of the people, their ways of life, welfare, and well-being, strengthening of the country's democratic institutions, safeguarding its territorial. What are the roles of NSTP to national security of the Philippines? The NSTP aims to promote the integrate values, education, transformational leaderships, spirit of patriotism and nationalism, and sustainable social mobilization for youth development, community building, and national security. Why national security is very essential? Solution. National security is very essential for the policy, social, and economic development of any country. It is also important for the growth of the country's peace and property. What is the National Police Commission or NAPOLCOM? In Filipino, National Police Commission or NAPOLCOM is pambansang komisyon ng pulisya. It is an agency attached to the Department of the Interior and Local Government or DILG. It is responsible for administration and control of the Philippines National Police or PNP. It has the authority to administer police entrance exam, to investigate police anomalies and irregularities, and to summarily dismiss erring police officers. What is the role of the National Police Commission? The National Police Commission is the agency mandated by the 1987 Constitutions and the Major Reform Laws Republic Act No. 6975 and 8551 to administer and control the Philippine National Police. What is the power and function of National Police Commission? The powers and functions of National Police Commissions is exercise administrative, control the operations supervisions over the Philippine National Police, which shall mean to the power to develop policies and promulgate a police manual prescribing rules and regulations, examine and audit, and thereafter establish the standards, establish a system of uniform crime reporting, conduct an annual self-report, survey, and compile statistics data, approve or modify plans and programs or educations and trainings, affirm, reverse, modify through the National Appellate Board, personal disciplinary actions. These are some informations about the power and functions of the NAPOLCOM or National Police Commission.
So, dito po sa judicial bodies is meron po tayong tatlo na dapat alamin. The first is taking and evaluating evidence. So, ibig sabihin, sila po yung kumukuha o sumusuri ng mga ebidensya o patunay na ipapasa sa korte. At hindi sila basta-basta tumatanggap ng mga ebidensya at ito ay kanilang hinihimay at sinusuri. The second is determining facts based upon the evidence presented. Dito ay they are the one who are collecting the facts. So, sa pagpasa ng ebidensya ay hinihimay nila ito at kinukuha yung mga matitibay na ebidensya na ipinasa. The third is rendering an order or decision supported by the facts proof. At after ng mga ebidensya na ipinasa ay magkakaroon ng judgment kung ito ba ay guilty or not guilty. At hindi sila basta-basta tumatanggap ng mga ebidensya ng korte. Kailangan ay may basehan at matibay ito upang ikay manalo sa kaso. Marami ding proseso ang mga ginagawa para maghatol.
So, ano nga ba ang due process? Ang due process ay ito yung pagbibigay sa isang tao ng karapatan niya kung meron siyang ginawang masama at dapat nakatukoy sa batas ng ating konstitusyon at hindi nanghihimasok sa karapatan ng pribadong individual.
Article 3, Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. Sinasabi dito na ang mga taong bayan ay may karapatan na magkaroon ng kapanatagan sa kanilang sariling pamamahay, papeles at mga bagay-bagay para sa di makatwirang paghalikho. Kaya nga may search warrant or warrant of arrest dahil isa ito sa due process of law to prevent government from impacting citizens in an abusive way. Notice and opportunity to be heard. Ang example nito ay freedom of speech. It allows us to express ourselves and opinions, for example, public protests or writing articles without government restraints.
Kaakibat nitong due process ay ang pagsunod sa Bill of Rights Section 1 na nagsasabing no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. And kasama nito yung Bill of Rights Section 14 na no person shall be held to answer for a criminal offense without due process of law. Itong due process ay hindi dapat lumabag sa karapatan natin, naturally born with as a Filipino citizen. So basically, ang isang kaso ay dapat dumadaan sa due process, kaya nga tayo may tinatawag na innocent until proven guilty. Ang isang akusado ay inosente hanggang siya ay masustensyahan ng korte. So ang unang hakbang dito ay yung pagbibigay ng pulis ng Miranda rights. Dapat ang inaakusahan ay binabasahan ng Miranda rights. Ano nga ba tong Miranda rights? Yung Miranda rights ay yun yung mga sinasabi ng pulis na may karapatan kang manahimik, ikaw ay inaaresto sa salang pagnanakaw. Ikaw ay may karapatang manahimik o magsawalang kibo. Ano man ang iyong sasabihin ay maaaring gamiting pabor o laban sa iyo sa anumang hukuman. Ikaw ay mayroon ding karapatang kumuha ng tagapagtanggol na iyong pinili at kung wala kang kakayahan, ito ay pagkakaloob sa iyo ng pamahalaan. Nauunawaan mo ba ito? Yun yung sinasabi nating Miranda rights. Paano kapag hindi binasahan ng Miranda rights ang isang inakusahan? Ang anumang sinabi niya magiging inadmissible. Lahat ng ebidensya na nakuha maaaring hindi tanggapin ng korte kapag hindi nasunod itong due process. Meron tayong tinatawag na judgment based on the evidence presented by the parties and on the applicable law. Sa huli, yung hatol na matatanggap ng akusado ay napatunayan ng korte sa binigay at napag-aralang ebidensya. So, ayun nga, yung hatol na makukuha ng isang akusado ay sa pamamagitan ng mga inihain na ebidensya at kung napatunayan ito ng korte, yun yung kung ano yung hatol na nababagay sa isang naakusahan.
Next, we have the Supreme Court. It is the highest court in the Philippines that composed of Chief Justice and 14 associate justices. Justices remain in the office until they reach the age of 70, and before that time, they may only be removed by an impeachment court.
Supreme Court power. Ang orihinal na jurisdiction ay nangangahulugan na ang Korte Suprema ang una at tanging korte na duminig ng isang kaso. Nililimitahan ng konstitusyon ang mga orihinal na kaso ng jurisdiction sa mga kinasasangkutan ng mga hindi pagkakaunawaan sa pagitan ng mga estado o mga pagtatalo na nagmumula sa mga ambasador at iba pang mataas na ranggo ng mga ministro. Pangalawa, repasuhin, baliktarin, baguhin o pagtibayin sa apela o sertyorya gaya ng maaaring itinadhana ng batas o ng mga tuntunin ng hukuman. Ang mga huling hatol at utos ng mga nakabababang hukuman sa una, lahat ng kaso kung saan pinag-uusapan ang konstitusyonalidad o bisa ng anumang kasunduan, international o executive na kasunduan, batas, atas ng Pangulo, proklamasyon, kautusan, tagubilin, ordinansa o regulasyon. Sunod ay ang lahat ng mga kaso na kinasasangkutan ng legalidad ng anumang buwis, impost, pagtatasa o tool o anumang parusang ipinataw kaugnay nito.
Ano nga ba ang jurisdiction? Jurisdiction is the power of the court to hear and decide cases and to execute the judgment thereon, and take note that is lodged with the court, not with the judge. It is not the power of a judge, but of a court. A court can exist without a judge in the same manner that a judge can also exist without a court. In fact, mayroon na ngayong tinatawag na Judges at Large, that is Republic Act No. 11459, otherwise known as Judges at Large Act of 2019. Madaming classes ang jurisdiction. The first one is general, special or limited, original, exclusive, exclusive original, appellate, concurrent, delegated, territorial. Well, distinguish now original jurisdiction from appellate. Question: meron bang original jurisdiction si Supreme Court? The answer is yes. That is very clear. According to our 1987 Constitution, Article 8, Section 5, the Supreme Court shall exercise original jurisdiction over cases affecting ambassadors, other public, ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. So, if you will be asked what is original jurisdiction, that is the power of the court to take judicial cognizance of a case instituted for judicial action for the first time under conditions provided by law. Kung si original jurisdiction is the court will hearing the case for the first time, that is not the case if you're going to talk about appellate jurisdiction. Bakit? Dahil si appellate jurisdiction, hindi na yan first time. That would be the second time or the third time. That because in appellate jurisdiction is the authority of a court higher in rank to re-examine the final order or judgment of a lower court which tried the case now elevated for judicial review. Si Supreme Court ba ay mayroon ding appellate jurisdiction? Yes, mayroon din. According to 1987 Constitution, the Supreme Court shall have the following powers: review, revise, reverse, modify, or affirm on appeal or certain as the law or the rules of the court may provide. Final judgment and orders of lower courts. Next, will distinguish general jurisdiction from special jurisdiction. When we talk about general jurisdiction, that is the power to adjudicate all controversies except those expressly withheld from the plenary powers of the court. Meron bang court na merong general jurisdiction? Yes, at ito yung RTC or Regional Trial Court. Pag sinabi namang special jurisdiction, that is confined to particular cases. Particular cases are limited cases. How about exclusive jurisdiction? That is the power to adjudicate a case or proceeding to the exclusion of all other courts at that stage. Sa Article 8, Section 5, dapat magtaglay ang Supreme Court ng sumusunod na mga kapangyarihan. Una, dapat gumamit ng original jurisdiction sa mga usaping may kinalaman sa mga ambassador, other public minister, and consul, and over petition for certiorari, prohibition, mandamus, quo warranto, at habeas corpus. Pangalawa, kailangan naman nilang i-review, revise, reverse, modify, or affirm yung mga maaring itinadhana ng batas o ng mga alintuntunin ng hukuman sa mga pangwakas na pagpapasya at mga kautusan ng mga nakabababang hukuman. Una sa lahat ng mga usapin na ang saklaw ng alinmang nakababang hukuman ay pinagtatalunan. Kalawa, lahat ng mga usaping kriminal na ang parusang ipinapataw ay reclusion perpetua or higher. And last, lahat ng mga usapin na pagkakamali o suliranin sa batas lamang ang nasasangkot.
Supreme Court has also the power to assign temporarily judges of lower court to other stations as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. Ibig sabihin po, sila yung may mga kakayahan na magpalit or mag-assign din ng mga bagong judges sa iba't ibang station in the judicial branch, like in the Court of Appeal, Court of Tax Appeals, and etc. as temporary or panandalian lamang as a request of the entire public interest or yung request ng mga public. And those temporary assignment has been given will not exceed to the said days, which is 6 months lang, without the permission and consent of the judges. Sila din yung may kakayahan na magbigay ng order na mabago yung venue or yung place kung saan gaganapin yung hukom para ma-prevent yung miscarriage ng justice.
So next po is the number 5 power of the Supreme Court. Here, the Supreme Court has the power to promulgate rules concerning the protection and enforcement of constitutional rights, treating, practice, and procedure in all courts, the admission to the practice of the law, the integrated bar, and legal assistance in the underprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts the same rate, and shall not diminish, increase or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. And this power po of Supreme Court, andito yung mga taong nag-aral at nag-practice ng law o mas kilala natin ng mga judge. Dito sila yung nagpo-protect sa mga batas para ma-enforce siya and yung constitutional rights natin ay magamit sa maayos na paraan at hindi lang maisantabi sa korte. Dito din po yung kapag may hearing o kapag may nire-resolve na kaso sa court, yung constitution po natin ang ginagamit ng Supreme Court para yung mga taong underprivileged na walang kakayahan na magbayad at magkaroon ng sariling abogado. Ang Supreme Court po ang nagpo-provide sa kanila ng public attorney na maglalaban sa rights nila. Meron po kasi tayong private and public attorney. Sa private, mga may privilege lang po ang kayang magkaroon nito, while in public, like what I said po kanina, sila yung para sa mga taong underprivileged. So, kung mapapansin po natin, pantay ang tingin ng Supreme Court sa pagitan ng mayaman at mahihirap. And it is because po in the Supreme Court, this is for those who are looking for justice and may power sila na alisin ang mga bagay na magbabiolate sa Constitution natin. It is up to the court to protect the citizens against arbitrary and unlawful acts of the other arms of the government.
These are the requisite of judiciary review. So, ano nga ba pag sinabing judicial review? So, judicial review is a process under which executive and legislative action are subject to review by the judiciary or nag-examine sa action if they are consistent by the Constitution. They are going to decide if there would be a conflict in a certain law. And if meron conflict, kailangan nila mag-decide if invalid ba ito or unconstitutionally. The following are the requisite of na dapat maisagawa or maipang before the court may exercise its power of judicial review. So, there must be an actual case, controversy raised by the property party and must be raised at earliest possible opportunity. So, like what I've said, that there must be an actual case or controversy. So, an actual case or controversy is one of involves conflict of legal rights and assertion of opposite legal claims susceptible of judicial resolution. The case must not be a moot of academic or based on extra-legal or other similar consideration not considerable by the Court of Justice.
Judicial review second requisite. The question of constitutionality must be raised by the proper party. The proper party is one who has sustained or is in immediate danger of sustaining an injury as a result of act complained of. For example, the patients of the physician and not the physician himself were the proper parties to question the constitutionality of a law prohibiting the use of contraceptives. The third requisite is the constitutional question must be raised at the possible earliest opportunity. Here is the general rule. If not raised in the pleadings, it is the written statement of the respective claims and defenses of the parties submitted to the court for appropriate statement. If not raised in the pleadings, it is to be considered at the trials, and if not considered at the trial, it cannot be considered an appeal. But there are also exceptions in criminal cases, in civil cases, and in every cases. In criminal cases, the constitutional question can be raised at any time in the discretion of the court. In civil cases, the constitutional question can be raised at any stage if it is necessary to the determination of the case itself. And in every case, except where there is estoppel, the constitutional question may be raised at any stage if it involves the jurisdiction of the court.